SJC-12850 in the matter of Doreen Zankowski.
Ms. Harbison, please.
Yes, thank you. Good morning, Your Honors. Pamela Harbison on behalf of the Office of Bar Counsel. This case involves an appeal by the Office of Bar Counsel regarding the sanction imposed in a bar discipline case of matter of Zankowski for what both the majority of the hearing committee and the board found to be intentionally fraudulent billing. The crucial question before this court is whether there was substantial evidence supporting the hearing committee and the board's findings that the respondent intentionally fraudulently billed her clients for hours that were not worked by anyone.
Why do you say Justice Gaziano didn't determine that as single justice? He said there's substantial evidence to support at least some of the subsidiary findings underpinning the board's decision that the respondent intentionally billed clients for time she didn't work. And I understand all, the argument and the amicus brief as it relates to the sanction, and I understand this argument's made about the tone and the implications, but he also said, I do not conclude that substantial evidence to support a finding that the respondent necessarily overbilled clients to the extent, I'm paraphrasing, that the hearing committee found and that the board determined. But again, he determined that there was substantial evidence of intentional misbilling of the client.
Well, I think that the respondent here admits that her bills are false, at least insofar as the time she billed under certain attorneys' names was not worked by that attorney. And I think that's what Justice Gaziano was alluding to when he said that there was substantial evidence that that happened, because in fact she admits that. However, taking the step further, that is where the hearing committee found at least 13 specific examples totaling 27 hours in which there was fraudulent billing that the respondent billed for hours that weren't worked by anyone. Not that the respondent put under some other, that she worked and put under some other attorney's name, but rather these were not worked by anyone.
Well, let's just take the depositions for a minute. I mean, there's nothing in the opinion that says that he's making different findings relative to the 7 depositions. Is there?
Yes, I believe there is. The hearing committee discussed the depositions with respect to the fact that first it's clear that the respondent did not personally attend those 7 depositions, right? She did not appear on the attendance sheets, and the senior associate who actually took the depositions testified that she did not appear at those depositions. That is something that is uncontradicted and was accepted by the hearing committee. But what the hearing committee rejected was the excuse that the respondent had that while the deposition and Mr. Boucher was conducting the deposition, she was actually working on deposition related issues during that same time period, that same day. And the hearing committee rejected that as not credible and found that her testimony lacked candor in that regard. And it's also important to note that the respondent never provided any evidence of the fact that she was working those hours at the same time that the deposition was occurring. And there are plenty of other evidence to indicate that the respondent didn't work any of the hours or most of the hours. And I want to go back to a point that you made, Justice Lowy, about the substantial number of hours. So even if Bar Counsel did not prove every single hour of the 450 hours that were added to the bills was false, the Bar Counsel did in fact prove a substantial subset of those were, at least 250 hours as enumerated by the hearing committee. And those
Excuse
include,
me, Ms. Harbison, I'm just having trouble understanding what the point of this is. I mean, I thought that Justice Gaziano was already basically saying that, okay, let's assume that she did intentionally, fraudulently, and dishonestly bill her clients for work that wasn't performed, and that it's that all of the subsections of the code that were charged, she in fact violated them. I take him as saying that. I think that what you're really arguing about is the sanction that was imposed and what it was that he did in connection with the mitigating factors. Isn't that true?
well, that is definitely an important part of my argument. However, I would say that actually Justice Gaziano found that there was a violation of Rule 1.5, which is an excessive billing finding. But that's not the same as an 8.4C intentional.
I thought he did. I thought he found everything. You're saying he did not find everything charged? You're saying that there were things that were charged that he did not?
He did not find that there was a violation of 8.4C, which is the fraudulent, intentionally fraudulent billing.
Okay.
So the question comes down to proving of intent. And I would state that intent is basically a factual finding based on the credibility of witnesses. And that is both the hearing committee and the board found substantial evidence that the intent to fraudulently bill her clients was there and proven by quote unquote a mountain of evidence, or amply supported in the terms of the hearing committee. I'm sorry?
Can I did you finish answering was it Judge Link's question? I'm sorry, I don't mean to.
Yes, I believe so.
Okay, my question goes to this idea of intent. And we have, when the board of bar overseers uses the word intent, and when we use it in criminal cases, or when we use it in civil cases, I'm wondering if it's really the same standard or quantum of evidence, or if it's the same level of proof, or if it is different, or if they have different meanings in different contexts.
Well, first we have to remember this is an administrative proceeding, so our burden of proof is less. We have to have substantial evidence, not a preponderance. The second is that I believe in my brief I did define what intent and needs to be, which is basically either intent to defraud or to misrepresent, or at least knowledge of the falsity and knowing that someone would rely on that falsity. And in this case, it's clear that the respondent knew that these hours were false, and that both the clients, the insurer who was paying the bills, and her firm were going to rely on those bills in terms of payment or success within the firm. There are plenty of things that are proven that show reliance and knowledge of the falsity. Going back to what Justice Lenk brought up, which is regarding mitigation and sanction, certainly believe that 6-month sanction is not nearly adequate.
Before you leave, I just want to make sure I understand, because I sense, particularly when I read the amicus brief, that there's a real distinction drawn between what you think the facts were found in with substantial evidence and what the single justice did. So I'd like you to take one last shot at conceptualizing where the fact finding here wasn't properly respected, if that's what you're saying, because Justice Gaziano clearly found support on the depositions. There's no doubt he found it there. I take it he also found some overbilling, but not the 450 hours that the hearing committee found and the board affirmed. I don't believe he addressed the 24-hour billing, the multiple instances of 24-hour billing and some of the other things. But can you, before you move to sanctions, I just want to make sure I understand where you think, we have to revisit the factual issues here on intentional and what we should look at, because I sense real people are very upset, particularly in the amicus, the former chairs, but I just want to make sure I understand factually where you think proper respect wasn't made for credibility findings or other things particularly, okay?
Certainly. So I think that as you say, proper due respect was not paid to the credibility findings of the hearing committee with respect to the respondent's own testimony. The hearing committee rejected her testimony over 24 times, 24 or 25 times, to say that she lacked candor, that they did not credit her testimony. Yet Justice Gaziano seems to really rely on the discredited testimony, the rejected testimony, that this was in fact a very busy attorney who had great market success, which is, I would point out, not the same as being an ethical lawyer, and that she just, the Justice Gaziano really thought that her testimony was persuasive, whereas both the hearing committee and the board found that it was not. And I think that therein lies the crux of my argument with respect to the substantial evidence with respect to the respondent's testimony.
Ms. Harbison, going to the issue, I think Justice Gaziano, Justice Capps is getting to. I mean, tell me if my memory is wrong, but I thought that Justice Gaziano found there was an 8 violation, 8C and 8H, if I'm remembering correctly, and that I understand what you're saying, and you said otherwise, but I think he did find that there was that bad faith in the building. I think the difference is on the dispute is the level of bad faith. And the level of bad faith certainly informs the sanction. But he indicates that he doesn't find substantial evidence to support all, or maybe even most, I can't remember the precise language, but he does find substantial evidence, it seems to me, of intentional misbilling.
I believe what Justice Gaziano found was that the respondent was careless in her billing. And that's been her story the entire time. That's been her testimony. She was careless. She had a messy and unreliable system for billing. And therefore, there was carelessness, negligence, but there wasn't intentional conduct. I'm sorry?
He found that there was intentional as well.
Well, not to the extent that if that's true, then the sanction is clearly not appropriate.
Okay, but we need your presentation to be accurate. I think it's on page 31 of the opinion. There's an 8C and an 84H and 84C violation. So it really goes to a disagreement about the level of bad faith. And it may be, and I completely understand this, that you're saying, well, he credited testimony that wasn't credited, or did, and that impacted the level of bad faith and therefore the sanction. But I think he found substantial evidence of an intent to be inaccurate with the bills.
But not to defraud the creditors. And I think, I mean, the clients, which I think is at the heart of the mitigation, which I think that you are correct, Justice Lowy, in that is really where the justice relied on mitigation that was either unproven or is not properly relied on. For example, the justice relied greatly on the fact that the clients seemed to be satisfied or were satisfied with the bills. But that avoids the issue in my mind, because whether or not the bills, there are plenty of reasons why the clients might have been happy with the bills, being that first, they weren't paying them themselves. They were going to either an insurer or to the third party pass through, or that they were billing less than the prior counsel. She was successor counsel in the ACI case. So the bills were lower. There are plenty of reasons why the clients might have been satisfied, but that does not go to the heart of the issue of whether or not they were honestly billed. And the fact that Justice Gaziano did find that she dishonestly billed her clients, then the sanction for that must be clear and unequivocally severe enough to protect the public
Let me
and
ask you this. See,
deter other lawyers. I'm sorry.
I understand. I completely understand, and we'll take a hard look at the extent of bad faith. But I'm having a hard time understanding the difference between him finding that she intentionally billed the clients for work she didn't do, and that saying that she was looking to the clients and billing them honestly. He didn't say that. He's saying she intentionally had sent the client bills for work she didn't do, and I thought, my memory is the same as Justice Capper's, that he didn't accept her testimony about the depositions in its entirety. So the way I understand the situation, which might be a little bit different than how you framed your brief, is the extent of the sanction and the tone of the single justice opinion, as opposed to that he ignored the findings of the hearing committee and determination of the board.
Well, I think that I think it goes back to the, if you want to go down to numbers, the numbers of hours that were fraudulently billed, and perhaps Bar Counsel did not prove 450 hours that was the number that was added to her bills during that 10-month period. However, there was at least a substantial subset of that. So you can't expect some sort of a dual standard to be, where do we draw the line? What fraud is too much fraud?
If I could ask one last question, I'm sorry.
Sure.
But one of the key differences, it seems to me, is that that the board basically is saying that what the respondent did here was done out of greed and self-interest. And Justice Gaziano has a different take on it. And the question is, when he has that different take on it, is he impinging on the credibility determinations of the hearing committee, or can he look at all the evidence and come to that different conclusion without impinging on their credibility determinations?
I think it does come down to the credibility of the witnesses. I think that it would impinge on the hearing committees and the board's findings regarding credibility. The only evidence that could be looked at, I think, in terms of not going toward, well, there's two things that I'd like to say. The first is that motive is not the same as intent. So whether or not she acted out of greed or some other intention, there could have been plenty of other motivations for her to overbill. But the fact that she intended to include hours that she didn't work in her bills is what is the violation of Rule 8.4C. And the second is that.
I ask? I just want to make sure I understand. So on page 31 of Justice Gaziano's decision, he finds a violation of 8.4C. So is that an intentional fraud finding? Has he made? I'm just trying to make sure.
I guess so. Yes.
Okay, so
that would be.
So he did make an intentional fraud finding. He just doesn't find the fraud as widespread as the hearing examiners and the board did, right? Is that right?
I believe that's correct, yes. And the inference, the logical inference, just looking at all of the facts, has to be that this was a pervasive pattern of overbilling. The 450 hours, the large round numbers, the billing for depositions she didn't attend, the billing for more than 24 hours in a day, all of these things added together lead to only one conclusion, and that is pervasive intentional overbilling, fraudulent.
But is that your essential disagreement with the single justice, which is that the single justice doesn't find as much of this as you do. He still reaches the same result on intentional fraudulent conduct, but he doesn't go into the fact that she billed 3,600 hours, that she billed more than 24 hours a day multiple times, and that it's not just the deponent issues, but there are others that, and is that, so it's amount of degree that is really, but at the same time you argue degree doesn't matter if there's any of this, it's justified. So I'm just trying to get a sense of why there's such concern about this. But I mean, I get it, but I'm just trying to think as a legal matter why there's such emphasis on the distinction.
I believe that, if my memory serves correctly, that the 8.4 violation that Justice Gaziano found was in relation to a reckless disregard for the truth, which is not what we are essentially arguing. It is a matter of degree. We are saying that she intentionally, knowingly, fraudulently billed, not that she was so negligent that it amounted to reckless disregard.
Where does he say it's reckless rather than intentional? Where in the decision is that drawn?
I can find it if you want to give me a minute.
So
While
you're
you're
saying
looking to find it, I'm going to repeat again. This is a quote. There is substantial evidence to support at least some subsidiary findings underpinning the board's decision that respondent intentionally billed client for time she didn't work. That's what he said. I mean, again, I understand that the single justice talks a lot about inadvertent, careless, and takes into account her personal circumstances and the view of the clients, and that may not be available from the credited testimony of the hearing committee. I don't know. We have to look, and that therefore it led to sanction that wasn't the appropriate sanction. And I get that argument. I'm looking forward to hearing the other side of it. But I'm having a hard time when you say that he didn't find that there was overbilling that was purposeful.
Well, to be honest, I'm having a hard time with that too, because I don't think that the opinion itself justifies the 6-month sanction. So I think again, it comes down to the severity of the sanction. I think by finding an 8.4C violation, we are automatically into a lengthy suspension, which requires a reinstatement hearing. And that is what both the board and the hearing committee found.
That's true, except that the fact that I think that he had factors in mitigation that nobody else had. And that's where I think that's where the rubber hits the road, is factors in mitigation that he took into account. Because he took into account the need to have uniform discipline across the board. And he was trying to find out which cases were really similar. He didn't really find them as being that similar because of mitigation, right?
But I think that the cases that he looked to were really just excessive fee cases. And those cases involve primarily a 1.5 violation, not an 8.4C. I think it's important to make a distinction between a fraudulent billing case and an excessive billing case. Those two things are very different, and I believe that the mitigation that was relied on by the single justice does not support this, was improper and does not support a 6-month suspension in this case.
Why was it improper to take those factors into consideration in mitigation?
Well, it wasn't proven. He relied a lot. I'm sorry?
What was that proven? Let's talk about what factors did he take in mitigation?
Well, in terms of the mitigation regarding her stress level, an illness in her family, she provided no evidence of a causal connection between that mitigation and her misconduct.
A causal connection between the fact that her sister was dying of leukemia, and that sister had been the one who provided care for a brother that was very disabled, developmentally disabled. And you know, common sense shows that that's going to be tremendously stressful. Well, what kind of proof do you want beyond that?
Well, I'd like to see something that says, you know, if she's saying that she's been doing this the whole time, I would like to see something that supports, some evidence that supports that mitigation during the entire 10-month period of of her misconduct.
But what
And-
evidence was there? What evidence was there as to the sister's illness and over what period of time the sister was ill, what period of time it affected the care she could provide to their brother for whom she was responsible? What kind of evidence was there on this?
There wasn't any.
You're saying there was no evidence of this? That just
Other than her
Gaziano-
testimony, there wasn't any.
Other than her testimony, which could have been, you didn't say that you didn't believe that at all, did you? This is like the hearing committee didn't
Her
say that-
testimony was discredited by the hearing committee over and over and over again.
In its entirety was discredited, or is in part discredited?
It was, I would say, in its entirety, when you read the
Where does it
hearing
say that? Where
committee,
does it say that? Where does it say that it was discredited in its entirety?
they specifically went through 24 different examples
Yes.
of when, and then they found, specifically with respect to the mitigation that I was just discussing, they found that there was no causal connection between the alleged stress. I mean, all lawyers who are billing in a high firm are stressed. That doesn't seem to be mitigation to
Not
me,
all
unless
lawyers who
you
lose
can,
their- No, that's the cancer and the obligation to care for a brother who's developmentally disabled. That is not a standard thing that goes along with a lawyer who's high stressed just because of work, right? And that's something different. That is a terrible personal dilemma, isn't it?
well, I think that if she was undergoing any sort of stress or of that level, then she would have been seeking some sort of treatment, and there was no evidence of that, of medical treatment at all.
Could I ask you, as far as the single justice's responsibility to not come to different factual findings in the hearing committee, can the single justice draw different inferences from the credited testimony?
I believe that the inferences that can be drawn, so long as, provided that there is substantial evidence supporting the inferences drawn by the board and by the hearing committee, that those should not be disturbed.
Okay, and one last question on that. Where it's just documents that are being reviewed, can the single justice draw a different inference from reviewing documents that were exhibits than the hearing committee?
Well, I think it's not just the documents. You have to take the documents in connection with the testimony of the associate, Mr. Boucher. I think you have to look at the testimony of General Counsel, Mr. Callahan. You have to look at the testimony of Mr. Baines, the department chair, and you have to look at the respondent's testimony that was then rejected by the hearing committee.
Do we have to, in order to justify a greater sanction, do we have to revisit the single justice's findings beyond the deponent? Meaning, do we have to find that, 3,600 hours, 8 days of 24-hour days in a year where she's traveling and other things? Do we have to revisit the factual findings to revisit the sanction? Or can we go return, in your view, to a 2-year sanction based on the facts that the single justice emphasized? Because I get that there's a significant distinction between the facts emphasized by the single justice and the facts emphasized by the board and the hearing officer. It's a much more egregious type of overbilling. And so do we need to revisit that to get to the sanction you recommend, or is a 2-year sanction possible based on the single justice's findings themselves?
I believe a 2-year sanction is possible based on the single justice's findings. Let's talk just about the depositions and pretend that there's no other issue before the court. Those depositions account for approximately 50 hours of time that the respondent intentionally fraudulently billed her clients. In Barak, there was only approximately 25 hours that were found to be fraudulent. In the matter of Broderick, it's not listed, but it certainly wasn't that that significant. And there's a case that is not included in my brief, and I can certainly supply it to this court pursuant to the appellate rules, called In the Matter of Montembeau. And the citation for that, I apologize, I believe it's, yes, 26 MADR 369. It's a 2010 reciprocal case. And in that case, an attorney in Maine was representing clients in a property dispute. They had asked the insurer about whether or not they would cover alternate housing. The insurer refused. So the attorney padded his bills to get $7,000 from the insurance company and then turn that money over to his clients so that they could be paid for alternate housing. So there was no benefit to the attorney, there was no greed, and yet in that case, there was a 2-year suspension, both in Maine and reciprocally in Massachusetts. So I will be happy to prepare the letter that's required under the appellate rules to provide you with that case.
Is there any other questions?
Kidding.
Thank you very much.
Well, thank you very much. All right, Mr. Mullen, please.
May it please the court, I'm anxious to get to the questions that you just raised, but if I may, there are 3 quick points I'd really like to make. One is that on the crucial question of whether Ms. Zankowski intentionally billed clients for time she did not believe had been spent, this entire case rests on a split vote of the hearing panel. 2 members ruled against her, but the third, who was one of the 2 lawyers on the panel, believed she was merely careless. He would have been content with a public reprimand. The majority's recommendation of a year and a day was clearly influenced by its belief that Bar Counsel should be able to extract restitution through a reinstatement process. But as the board found, this is not a case where restitution would be fair or appropriate because Ms. Zankowski did not receive any of the fees that were refunded by her firm. Second, every case about excessive fees makes the point that this is all about the clients. Here, after full disclosure of all the allegations, 2 of Ms. Zankowski's clients, who collectively accounted for almost 4/5 of the fees that are in question here, testified on her behalf, subjected themselves to cross-examination. They even attended the single justice's hearing, and they're watching right now.
But it's not, Mr. Mullen, it's not all about the clients. It's about protecting the public and the integrity of the profession.
It certainly is. I agree. And if I can, I'll just get to the questions Your Honor raised in a second. But the third point I just wanted to make was that to the extent this is about sending a message, the court may rest assured a message has been sent and received. The amicus brief trivializes the 6-month sentence that my client has already served. There was nothing trivial about the sentence or about notifying all of her clients and her partners about the suspension and the reason for it. Nothing trivial about appearing on the front page of Lawyers Weekly. She couldn't even continue to serve as the guardian for her disabled brother without getting leave of court. And because Bar Counsel is now seeking the extraordinary penalty of resuspending somebody who's already fully served her 6-month suspension, the effect on Ms. Zankowski has already lasted far longer than 6 months. And if she were suspended for a period that put the total suspension over a year, she'd have to apply for reinstatement, which would guarantee still more months of being unable to practice.
I'm confused, Mr. Mullen. She is already, because of this, her suspension is already longer than 6 months? I'm confused. She's not returned to the practice of law. How long has she actually been suspended from the practice of law?
Okay, I'm not saying that she was suspended longer than 6 months. I'm saying that the effect of the penalty on her practice has already lasted far longer than 6 months because her 6-month suspension ended June 23rd. That's more than 3 months ago. She has had to notify all of her clients and her potential clients because of the pendency of this appeal that she might have to be resuspended in the future. And
But she's been practicing. She's been practicing during that time period. Okay.
She has. That's right.
So she.
On the question that I think one of the justices, I'm sorry, I forget who, raised about exactly what violations were found by the single justice. He did find that there were violations of 1.5A, which is excessive fee, 8.4C, which is misrepresentation, and 8.4H, which is the catch-all about fitness. I do not read the single justice's decision as finding that there was substantial evidence for a finding of any particular number of hours having been billed to clients with the knowledge that the time wasn't spent. Instead, on page 29, the judge said, I agree with the respondent that the large number of hours she reported in 2015 is not substantial evidence that all or even most of the 450 hours at issue in this case were fraudulently billed. And on page 31, he says, the multiple instances where the respondent testified that she had entered her own time as the time of one of her 4 or 5 associates plainly establishes violations of these 3 provisions. I read the justice as saying, 1, Ms. Zankowski was terribly careless, and 2, that she admits to attributing some of her time to her associates. And that was explained at the hearing, and the reason for it was because Ms. Zankowski, during this, the busiest year of her life, and with scant associate support, had to suddenly do a huge amount of document review and other low-level associate-type work by herself late at night. She didn't regard that as associate-level billing material, and so she wanted to give her clients the benefit of the doubt.
That was not credited. That was just not credited. That kind of testimony was just not credited. So why don't we get off of that? Why don't we just move along?
Well, if I may, let me get to the issue of credibility. Certainly the panel's credibility determinations must be given weight, but review—
Dispositive weight? Dispositive deference?
Well, a review cannot be avoided by putting a credibility label on every finding. And when the panel majority tells us that they differ from the dissent for specific reasons, they invite us to examine those reasons. And at least 2 of the reasons given by the majority are just flat out 180 degrees wrong. They found that, they said that one of the reasons they disagree with the minority was that Ms. Zankowski was motivated by greed. She was anxious to recoup monthly income lost when she became an equity partner, and that the additions of her time through the year increased. None of that is true. It's clear in the record that she knew she'd be making much more money as an equity partner than an income partner. And her additions to the bills—
Not during 2015, not during 2015 she would.
I'm sorry?
Not during 2015 she wouldn't be. She'd be making 60% of the, she's taking home a draw of 60% of the $575,000, which is less than, so she would make it up in 2016 for sure, but she only depending on how she performed in 2015, presumably.
That's right. And
2015, there was a transition year, right? 2015 was a transition year from income to equity partner.
It was, and during that year, there was nothing that she could do that would have changed the amount that she would get on a month-to-month basis. And she understood that there'd be a true-up at the end of the year that would more than make her whole. So that, but beyond that—
But just to push that, Mr. Moen, because I know you understand partner dynamics. The more she bills, the more she makes if the firm is successful. So whether it's characterized as greed or whatever, I don't know what the right adjective is. She's got enormous incentive to bill more because she's going to make more. That's the simple dynamics of being in a law firm and being a partner, an equity partner, right? I mean,
well, okay, I agree. Obviously, there's a potential incentive to bill more.
It's more than just a potential. That's why people like law firms and like being in big law firms. They make lots of money that way, right?
Her total billings for the year more than doubled over her best year previously. She went from something like 1.7 million to 3.6 million. The 200.
I'm not sure that's a good thing to compare when we're talking about billing. I mean,
And by the way, she wouldn't control the bills, right, as an income partner, right? The equity partner would be filing the bills when she was an income partner. Is that correct? Or was she filing her own bills as an income partner?
I believe she was filing her own bills even as an income partner.
She was, okay.
Yeah. There was certainly no evidence to the contrary.
And even though she had gone beyond the time in those cases, she never went beyond the time, like $200-something thousand that she did in this case.
But
I mean, you've got a real problem here because her partners who were making more money as a result of what she was doing, was still not happy with her. They still thought there was a problem with what she was doing. You've got a real problem with that.
yeah. So her $260,000 that ended up being refunded to certain of her clients amounted to something like 6% of the billings for that year. And they did not, unlike what the panel said, majority said, they didn't increase. That is, the additions at the draft bill stage did not increase throughout the year. Rather, they tracked the extent of her work. So in January, the changes she made actually resulted in a reduction of the bills that she sent to clients. And this, you can see this in Bar Council's Chalk 1. And then it didn't actually spike until March and February, when a new case and thousands of documents were dumped on her. It spiked, it reached its height in June, which was the busiest, most ferocious month of litigation. And then it trailed off through the rest of the year. So one of the points made by the panel's majority explaining the credibility determination they made was just simply wrong. The other point that they made in support of their credibility determination was they said, she's much too careful a lawyer, much too careful an engineer to make sloppy billing mistakes like this. But there was uncontradicted evidence that she had always followed the same chaotic billing process, first at Hinckley Allen, the firm she started with, and then at Saul Ewing. And that was supported by her administrative assistant, who served her in both firms and who testified that at all times, her job was to assemble her boss's time from a kind of dog's breakfast of emails, Outlook calendars, notepads, correspondence, whatever else lay on her desk. And that Ms. Zankowski made some edits on a weekly basis, but also entered time and changes at the draft bill stage. Now, this was indefensibly messy. I don't mean to defend my client on that.
Well, isn't that, I mean, I'm just, when we get indefensibly messy and we get 3,600 hours and we get 8 days of post 24 hours of billing in one day, don't we have some issues about finding the facts found by the hearing commissioners and the board not credible that this was more widespread? Because these are, I mean, I've never heard of anyone billing 3,600. I mean, that's an extreme number, particularly for a partner, right? You know, some poor associates may be billing in the 3,000 range, but I've never heard of partners billing at 3,600 hours.
It would be a lot of work, Your Honor, I agree.
Well, not just a lot of work, it's over 10 hours a day, 365 days a year. I mean, it's extraordinary.
So early in the year, she had a 1 month total that would have worked out annually to 4,000 or more hours. And the firm didn't launch an investigation. They sent her a thank you note.
Well, 1 month may be something, but sustaining that, the big picture here gets troublesome if we owe so much deference to credibility findings. And the billing practice itself is, I've never heard of anything like this before. Have you? Where you have your secretary figure out what you did a month later. Everyone has to figure out what they did the day they do it, or they're not going to remember it. So there's a level of extraordinary here that gets into credibility deference, doesn't it?
Well,
That's right.
Yeah. On the point Your Honor makes about maybe you could put up with something like this for a month, but not longer, I have to emphasize 2015 was I think it's annus mirabilis is the Latin for it. It was the year that she had 3 large bet the farm litigation cases involving 84 depositions, 26 hearings. That's a hearing every other week and a deposition every 3 business days. And at the same time, unlike most partners at law firms, she wasn't just a litigator, she was also a corporate lawyer.
Well, hold on, Mr. Mullen, I'm just trying to understand, are these the depositions that undisputably she took, or are these the depositions that Mr. Boucher and others took for her?
It includes both.
Well, but that's a big difference. You know, a partner can be responsible for their associate taking a huge number of depositions and doing things. It's another thing if they're doing it by themselves, right? I mean, I'm not saying she's not working very hard, but at a certain level, this becomes incredible, doesn't it?
Well, with respect to the depositions, I think there were entirely credible explanations that were put forth, and they convinced, again,
Well,
one
they
of
were
the...
inconsistent with the associate's very assiduous documentation of his hours, and clearly the firm separated from her, reported her to bar counsel, which was their duty, and reimbursed the client. I mean, there's a lot of support here in the record. And she's now trying to recreate things a month later that she couldn't remember at the time. There's a credibility determination by the board with a lot of support for it. The question is whether or not there's, because the single just has to look at the entire record, whether in the there's also within the record, without discrediting what was credited, enough to come out with a single justice.
So in matter of Fordham, this court said that it is, and the single justice is, empowered to review the board's findings and reach its own conclusions. And the court in that case reversed determinations made by both the hearing panel and the board. Here, the single justice adhered to the findings of the 3 violations, just found a narrower basis for them based on the fact that the only reason why 2 of the hearing panel members failed to credit Ms. Zankowski, where the 3rd did, included some blatantly unacceptable false reasons. And as for the depositions, there were only 7 out of the 84 that are in question. And in most or almost all of the cases, it's what's at stake, what's at issue here is that my client used the generic term deposition of X in a bill, meaning...
Well, she twice said attend. She said she was attending those. She said she attended those.
Well, yeah.
Well, at least on 2 occasions she did. I mean, so, I mean, why don't we go past this? I mean, those 7 depositions are shameful. She should not have billed for them.
Well, it was generic terminology that she used, meaning that she was working on the same subject matter during the deposition. And in at least one of those cases, there was actual documentation submitted to the hearing panel to prove that. That was the Taylor deposition, where a deposition had been scheduled and it had been postponed. My client used that day of postponement very constructively to come up with cross-examination materials that helped her nail that witness when the deposition eventually occurred.
Well, counsel, there's no question she has demonstrated exceptional legal skill and ability. What I would like to ask you about is a question I asked your sister, which relates to intent. How do you understand, what do you understand that to mean in this case? And what level of proof do you think the board was held to? And is it different from the way we define intent in civil or criminal cases?
So my understanding here is that the majority of the hearing panel concluded that my client intentionally billed her clients for time that she knew she had not spent. And the single justice, I would say correctly, assessed the entirety of the evidence, which he is entitled to do, and determined that there was not substantial evidence to support that. What there was substantial evidence for was the contention that A, she had been careless, and B, she had knowingly attributed some of her time to her associates. And that's a misrepresentation. There's no excuse for it. My client understands that now, and she's practicing in a very different way.
Okay. Anybody have any other questions? No? All right. Well, thank you very much, Mr. Mullen. Thank you, Ms. Harbison. We'll get back to you. Thank you.
Thank you.
And that concludes today's session, I think.
Okay, thank you.
Thank you.